Hello, Major Steve Dre here with,
Lieutenant Colonel Sean Lister.
and we're here to discuss United States versus Palacios Cueto. Sir?
Yeah, so this case is about really two issues. One, ineffective assistance of counsel, and then the second would be prosecutorial misconduct. It's important to keep in mind that the alleged crimes occurred in 2018 because that has to do with allegations of ineffective assistance of counsel that the accused brought up against his civilian defense counsel and trial defense counsel on appeal. The statute changed in 2019, and so some of the misconduct would not have been a crime under the 2019
At least
statute.
this crime would have been this crime.
Right, would not have been abusive sexual contact, as we'll talk about here in a second. But the facts of the case are that the accused was an airman first class assigned to Hanscom Air Force Base, and he and the victim in the case, and we'll call her airman first class MT, or just MT, they went out together for a night of drinking off base. At some point, they returned to base and they continued to have some more drinks, and MT became intoxicated. Airman first class MT became intoxicated. The accused walked her back to her room, and there's surveillance video from, I think it's the hallway. Some of the common areas of the barracks must have surveillance videos. And there's video that show the accused kiss MT and then follow her into her room. She went to bed soon after entering the room, and she testified her last memory before falling asleep was the accused touching her stomach. When she woke up the next morning, the accused was in her bed wearing only his underwear, and she believed that she had been sexually assaulted, so she tossed him out of her room and then immediately reported. And as a result, after an investigation, the accused was charged with one specification of sexual assault and two specifications of abuse of sexual contact. And the abuse of sexual contact that was alleged was the kiss in the hallway and the touching the stomach, right? And that's why differentiating between the 2019 statute and the 2018 statute is important in this case. The accused was sentenced, so he was convicted by a panel of the two abuse of sexual contact, acquitted by the panel of the sexual assault, and then sentenced to reduction to E1, a bad conduct discharge, then 90 days of hard labor without confinement. The convening authority disapproved the hard labor without confinement and then took no action on the remainder of the sentence. Air Force Court of Criminal Appeals affirmed, and then this went to C.A.A.F. And then the issues at C.A.A.F. were allegations of ineffective assistance of counsel against the civilian defense counsel and the trial defense counsel, and then prosecutorial misconduct against the trial counsel for making improper statements during voir dire, opening, closing, and sentencing. C.A.A.F. affirmed. They held there was no ineffective assistance of counsel, and then they also held, with respect to the prosecutorial misconduct, that although the trial counsel made several improper statements, it was not severe enough to affect the substantial rights of the accused.
And so, sir, we'll talk about the statements later. We'll get into the specifics. The takeaway from this case is not that what the prosecutor said was proper. In fact, they find that, and we'll talk about them in a minute, what the prosecutor said was improper. At least 6 different times what the prosecutor said was not something that the prosecutor should have done, but that it wasn't so prejudicial to the accused that it likely resulted in a different outcome.
Right, and you know, I think that, you know, allegations of improper argument by prosecutors is the number one reason that cases go up on appeal for allegations of prosecutorial misconduct. And I'm barred in the state of Maine, and I get my state Supreme Court's cases sent to me in email. And just last month, there was a case that got overturned by the Maine Supreme Judicial Court for prosecutorial misconduct for improper argument. So this happens in the military. There's probably, I think there's like 17 cases at least, just C.A.A.F. cases that talk about prosecutorial misconduct. And so this is an area where, I think that our military justice leaders probably need to spend some time doing some training because of the frequency it happens. It happens in civilian courts, it happens in military courts, and it's something that's avoidable. In this case, could have turned out differently but for the actions of the military judge, like we'll talk about.
Right. It's okay to be passionate. It's okay to bring some energy to your arguments, but you gotta know the rules. You gotta stay within the confines of the rules.
Yeah, as you argue the evidence, you can't appeal to the passion, and that's kind of what this prosecutor did. He used the word justice at least 8 times.
In a bad way. We'll get to that. We'll keep them in suspense. Let's talk IAC first, sir, because the CAAF dealt with IAC first. What happened here?
Yeah, so good news for defense attorneys. It's hard for defense attorneys to commit IAC. And, the standard is whether the counsel's conduct falls within the wide range of reasonable professional assistance. And so in order to prevail, the accused has to show that the conduct was deficient, right? So it falls outside the range of reasonable professional assistance. And then if it does, then the deficiency caused prejudice. And so the CAAF in this case talks about, and it's a really good discussion. I think it's a really good case that kind of walks counsel through how to approach these problems. And so with respect to, basically the allegations are lumped into kind of 3 buckets. One of them deals with kind of collateral consequences. So one of the allegations was that the defense counsel failed to advise the accused properly on sex offender registration, and then it didn't advise the accused to mention the fact that he would have to register as a sex offender in his unsworn statement. Likewise, there was a similar allegation that trial defense counsel didn't properly advise or tell the accused to discuss the mandatory discharge, either in his unsworn statement or in their sentencing argument. And the CAAF said, well, it wasn't unreasonable for the defense counsel not to do those things because the judge would just give the proper instructions that collateral consequences resulting from the conviction aren't appropriate considerations for the panel in sentencing.
Right, so let's just break down exactly what happened here and why the CAAF found no error here was because the appellant's position here is that he was not advised to bring up the collateral consequences of sex offender registration in his unsworn statement. And we know that when an accused generally has a wide ability to offer information during their unsworn statement without being cut off, but the panel is going to get an instruction that they can essentially disregard the nature of collateral consequences described by an accused in an unsworn. And the reason for that is because essentially courts have taken the position that there are too many collateral consequences out there to know exactly what is going to happen as a result of the findings. Okay, and so here, essentially the position is that they are irrelevant to a sentence, right? This is happening during the sentencing proceeding, and so the sex offender registration, other types of collateral consequences that happen as a result of the findings are irrelevant to the sentence, right? Whether a sentence is 0 or life in prison, the collateral consequences are going to be the same. Is sort of the position, and that it's difficult to divine exactly what'll happen, and that's part of the appellant's position here too. Is that I didn't have the opportunity. I wasn't told that I should discuss the fact that I'm going to be probably definitely administratively separated if I don't get a discharge. That was also something that I should have been informed to talk about during my unsworn. My attorney should have discussed it, and they didn't, and so that was ineffective. Which is actually a pretty interesting argument. If you think about the argument about the administrative discharge is pretty interesting because on appeal his position is that, that the administrative discharge is a consequence of the sentence, not the findings, because if I'm not punitively discharged by the panel or the sentencing authority, then that administrative separation will now be relevant. And so an interesting position, but the CAAF found that it was not clear from the record that a administrative separation would definitely occur as a result of a conviction but no discharge here. And so that's part of the reason why the CAAF found it not to be deficient performance.
Yeah, and in fact, the panel sent back a question while they were deliberating, asking if the accused would have to register as a sex offender, and the judge gave them the proper instruction. And so I think that factors into the reasonableness of the defense counsel's decision not to bring that up, knowing that it's not a proper consideration.
Right, it was before the panel, they had it, they got this instruction, and that this instruction essentially is you can disregard.
Right. And the funny thing about the required initiation of separation, or the required separation, the out there that CAAF used is the fact that a person convicted but not punitively discharged can request an exception to policy, and
Right.
it may be granted.
Right.
And so because it's not a sure thing that the person's actually going to be separated, that's what they kind of hung their hat on that issue.
But that's, that's an important takeaway about collateral consequences. The courts just, we don't know, we can't figure it out. We're not gonna have a trial within a trial about what may happen as a result of your conviction, and so not really relevant for the sentence.
Yeah, and going way back to when I was trying these cases full-time, back then defense counsel would consistently try to bring in the collateral consequences in sentencing and were uniformly shot down in those attempts. And so I just think over almost a decade and a half since then, the defense is just, okay, we know we're not going to be able to talk about this stuff, and so that probably goes into their decision-making process. But good try by the accused to bring that up, good try by the defense appellate attorney to try a long shot, but they went for it. And then the other thing they argued was, two other things they argued. One was that they failed to bring to light that under the amended statute, and this is the difference between the 2018 statute and 2019 statute when the case went to trial, they failed to bring to light that under the revised definitions in the new statute, his conduct would not have been abusive sexual contact. And the CAAF said, well, the military judge would have instructed them to disregard that on the basis that they would be instructed to apply the law at the time of the offense. And so the fact that the statute had changed by the time of trial was irrelevant. And so it was not ineffective assistance of counsel for the trial defense counsel not to try to argue try to imply through argument or an unsworn that the new statute somehow is relevant to this. And then the last thing they brought up was just overall deficiency in the defense counsel, their overall performance in the sentencing. And the CAAF said that, an appellant will only be successful in these cases when the conduct, where they can show that show a long series, so they can point to a long series of omissions by counsel that were not simply the product of human fallibility, but the result of the result of a lack of conscientious effort, right? So an absolute lack of effort, not just a mistake. And none of the conduct, as they looked through the record, there was no indication in the CAAF's mind that these trial defense attorneys had just a lack of diligence in representing their client.
All right, sir, let's turn to the prosecutorial misconduct issue that the CAAF addressed here. The 8 instances in which trial counsel made an appeal or reference to justice. And it's more than just calling this case about justice, right? And I'll give you some examples of them. The prosecutor said that he was representing the United States of America in the pursuit of justice in this case. Maybe that's not the worst thing that somebody could say. But then we've got some other examples here where he's equating justice with a finding of guilty. That's the problem. It's not necessarily calling justice out for the panel to apply. It's saying, here's an example, I ask you all to repair the little that can be repaired and bring justice by finding the accused guilty, right? It's not bring justice by weighing the facts and the evidence and making a decision. It's is equating justice with only finding of guilt. Another example is whether justice will be served or whether the accused will be acquitted, right? It's an either or, and justice is on the side of conviction, not a objective analysis of the facts. And so, right, another one is choose between serving justice or finding appellant not guilty, right? Another bad example. And so here the Civilian Defense Counsel, though, was not objecting to these
Yeah, that's the key.
statements by the government. Yeah, so sir, let's talk about that.
Yeah, so I mean, so the bottom line is, what was so wrong with what the trial counsel did was suggesting through the use of the term justice and choosing between justice and a finding of not guilty is suggesting to the panel that it was their military obligation, their duty to find this person guilty, and that they wouldn't be doing justice unless they found the person guilty. And so that was why the comments were so inappropriate. But yeah, you point out the big problem, and so when I teach, when I teach this to our advocates that come through the school, I tell the trial defense attorneys object, because it makes a big difference in the standard on appeal. If you object to improper argument, then it's going to be a de novo standard, and you'll have a much better chance on appeal of succeeding. Here they didn't object, and now we're on a plain error standard. So again, the military judge gets maximum deference, and so that's really most of the cases in this kind of along this line. The 17 or 18 cases now that deal with prosecutorial misconduct for improper argument. Most of the time, they turn on what the standard of review is and whether the defense objected. And so that's it's a portent in how this case turned out. But they do a good job talking through if the misconduct materially prejudices a substantial right of the accused. And the test for that is the severity of the misconduct, the measures to cure, and that's key in this case, and the weight of the evidence against the accused, right?
When we're talking harmlessness, the harmless analysis is whether it would have had an impact on the results of the case.
Right.
And here, right, so we're looking at error, and the court does find the court finds that at least 6 of the 8 statements by the government attorney were error, that they exceeded the left and right limits of what a prosecutor can say, right, that equating justice to conviction, essentially. But that prejudice test that you just mentioned, sir, here for prosecutorial misconduct, we're looking at the severity of the misconduct, the measure adopted to cure the misconduct, and then the weight of the evidence supporting the conviction. And so the CAAF finds that this was moderately severe. Okay, so it's not the worst prosecutorial misconduct ever, but it's not the least. But then noted that the military judge gave an instruction that, right, that's the cure, is about the CAAF found that effective curative measures were taken. The military judge gave the members complete and correct instructions and informed the members that the instructions should control their deliberations. So really what that is just the military judge gave the instructions that they were supposed to give without any evidence that the panel considered those statements. That's sort of what we're left with. And then last, the CAAF found that the weight of the evidence supporting the conviction was moderate. All right, so these statements were bad, they were error by the prosecutor, but the government's case was reasonably strong. They had corroborating evidence of what the victim said. They had a video of the appellant kissing her and entering her room, and then there was medical and forensic evidence that was not inconsistent with Airman First Class MT's testimony. So CAAF also found that the members gave a sentence that does not appear to have resulted from inflamed passions, and that's what we're concerned about with improper argument, that people are sort of, instead of using the rules and the instructions and applying them, that they're sort of making decisions based on emotions that have been triggered by the improper argument. And the CAAF found that they just didn't find enough here. And if you're not going to read the whole case, at least read the snippets of what not to say.
Yeah.
Justice is not the same as conviction. All right. Okay. Anything else?
No.
All right.
No, thank you.
Thanks, sir.